Hello, everyone. My name is Giovanni Nogales, and I am a paralegal here at Liles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled, Are You Personally at Risk? Update on the DOJ's push for individual accountability. Today's presenters are Robert Liles and Robert Saltaformaggio. A little bit about them. Robert Liles has worked on the healthcare provider side as a federal prosecutor and now defends home health, hospice, and other healthcare providers around the country in Medicare, Medicaid, private payer audits, and False Claim Act cases. While working as a federal prosecutor, Robert was asked to serve as the country's first national healthcare fraud coordinator for the Executive Office for U.S. Attorneys. In this capacity, he advised federal prosecutors around the country regarding healthcare fraud, statutes, schemes, investigative tools, privacy concerns, and compliance issues. As for Robert Saltaformaggio, he is a senior counsel at Liles Parker. He focused on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Robert represents clients nationwide. He has experience in assessing clients' records for documentation, compliance in private payers, and CMS audits preparations, as well as identifying and improving documentation deficiencies. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present your speakers, Robert Liles and Robert Saltaformaggio.
Thank you very much, Gio. Hello, Salt. How are you?
I'm doing well, Robert. How are you?
I'm doing fine. For the folks on the line, Salt is joining us from Nashville, Tennessee, which of course is the center of the healthcare universe. And today we're going to be talking about personal accountability and whether or not DOJ will be going after them in their individual capacity. Let's go to the first slide. Can we there, Gio? And we've got 4 or 5 slides that kind of lay the foundation. I'm going to go over these kind of quickly. I don't want to spend a whole lot of time over them, but I do think that they're important to kind of tell the story. And the story kind of starts out like this. If you go back all the way to the beginning to 2001, and it's a long way back, and you look at Enron, you'll see that in those days, the government actually went after individuals that were found to be culpable for fraud, and that was something that was important, and that was under Bush 1. But then, I'm sorry, that was Bush 2. But then under the second term of Bush 2, okay, then we had the bank crash. It was the very end of Bush 2, the very beginning of the Obama administration. And in that particular case, I mean, that was a worldwide crash. And you'll see that unfortunately, they really didn't go after individuals. They only went after the banks themselves. They really didn't hold people accountable, and that was really unusual. So it was, kind of they ebbed and flowed in terms of liability. Next slide. Fast forward to 2015, we saw that under the Obama administration, they made it very clear that they were going to start going after individuals. And Sally Yates, the Deputy Attorney General, actually issued guidance to DOJ, and they made it very clear that they were going to start going after individuals that were culpable for the wrongdoing that occurred at these corporations. And it kind of makes sense, doesn't it, Saul? Because, corporations can't break the law. It's individuals in corporations that break the law. So they ended up issuing guidance that kind of laid out what the rules of the road were going to be. And these are the 6 basic rules that they were going to follow. And these rules are something that we're going to kind of come back to later on under the Biden administration. But if you go to the next slide, you'll see that what happened was, though, as soon as there was a change in administration, in the Trump administration, they came in, and what's the first thing they did was they went back in and they kind of went back on that, okay? And they said, well, under the Obama administration, corporations were required to really kind of disclose any individual wrongdoing by individuals in their corporations that had conducted improper acts. We're no longer going to require corporations to disclose that. We're just going to require them to work with us. So it was, they really kind of walked back from that. Next slide. Now, of course, we're back to where we were under the Obama administration. So what does that mean to you, Salt? Where are we now?
Well, right now, like you said, they essentially have gone back to the Obama administration where, they're really going to start focusing not just on those who were substantially involved, but they're really going to start targeting any individual who had, culpability. And so I think that's, you see with the Biden administration really going back to, what the Obama administration did and said, hey, we want to kind of facilitate and foster an environment among, the corporate world that, it's just not the higher ups that we're going to target. We really need to make everyone from the CEO down to the lowest level employee is going to be responsible and held, liable for any corporate misconduct. Next slide. And, even, Ms. Monaco kind of issued some updated guidance, that really focused once again on targeting any individuals who may have, committed any corporate misconduct. And, they're really trying to foster this ethics and corporate, compliance environment that is really kind of telling corporations, hey, you really need to build it into your compensation plans and your employee, conduct plans that say, put forward right from the beginning that, hey, if you're an employee, you're going to be held responsible for any misconduct. And again, that goes from the lowest level employee to the highest level, CEO. And so, what I think is going to be interesting, Robert, and is if the Biden administration, if they're reelected this November, if they're going to, continue this, or, if former President Trump is reelected, if he's going to revert back to his old philosophy, or, given kind of more of this populist rhetoric, I think that we're seeing from both parties, would a second Trump administration kind of continue these efforts against big business and all corporate accountability?
It'll be interesting, no question about it. But before we move on to the next slide, Salt, your point though, and this has been borne out over the last 4 years in prosecutions, if you look at the healthcare cases that have been prosecuted, we've seen them go after the owners of home health and hospice agencies. We've seen them go after the folks involved in marketing. We've seen them go after the administrators, people involved not on the home health side, but on the physician practice side. We've seen them go after people involved in improper coding and billing. The point is, when it comes to healthcare, anyone involved in the submission of the improper claims or in the performance of services that are illegal, that involve kickbacks or improper business practices, they've been going after them. And Salt, your point is exactly right. From the very lowest position, from someone, a biller or a coder or a person involved in marketing services, that it doesn't qualify for the personal services safe harbor or the employee safe harbor, they will go after them, and they have been going after them. And that's what this whole presentation is about. And that is the old days where they would just go after the corporation and shut the corporation down, those days are over. And the folks on this phone, you need to understand that if your organization is involved in conduct that would violate one of these civil or criminal statutes that we're going to be talking about, you got to do something else, because the government will go after you. Next slide. Okay. It looks like this is the most recent missive, doesn't it, from the government? And what does this one have to say, Salt?
Yeah, so essentially this is telling companies that, hey, if you're a home health or a hospice provider and you're looking to purchase, a competitor or whomever, it really behooves you, when you're going through all those contracts and documents from the company that you're going to acquire, it really behooves you to do your due diligence, because the government is saying, hey, if you are looking through all of those records and you find something that raises your spidey senses and looks like it's misconduct, you need to disclose that to the government, because you're likely to receive a presumption of declination that you had anything involved. You can't just put your head in the sand and act like you didn't see anything, and then 5 years down the road say, oh, hey, government, there was all this misconduct that was happening before we bought the company. Well, the government's not going to buy that argument. So again, if you're looking to acquire any companies, it really would be in your best interest to comb through all those documents with a fine-tooth comb, and if you find anything wrong, to disclose that to the government. What do you think, Robert?
Well, it's really interesting, because there's a couple of ways when you purchase a company. There are really two basic ways that they buy these companies, right? I mean, they buy them as an asset purchase or a stock purchase, right? If it's an asset purchase, you're buying the sticks and the bricks. Yep. You're not really buying the liability. But most of the time in healthcare, they don't buy the sticks and the bricks. They buy the company as it is, because they want to buy it with the numbers. Because otherwise, if they have to do it otherwise, then they have to go out and they have to get re-credentialed by Medicare and Medicaid and all the payers. And it basically puts them out of business for a significant period of time, and they can't bill, and it costs them a lot of money, right? Well, when you buy it as an asset purchase like that, okay, or I'm sorry, as a stock purchase like that, you buy the liabilities too. That's the problem. And what they're saying here is, if you're buying these companies, first of all, you ought to be doing due diligence before you buy them. You ought to know what you're buying. But once you get these companies, once you buy these companies, if you continue to do due diligence and you run across something, no matter how deep you do your due diligence before you buy a company, you're going to find, once you actually own the company and you have full access to everything, you're going to find problems that you never knew existed before. And to the extent that some of those problems that you identify are evidence of improper billing practices or improper conduct, if you bring that to the government essentially is saying here, bring it to us, let us know about it, and we're going to essentially treat that as a safe harbor. We're going to give you there's going to be a presumption that we're going to decline taking action against the company, okay? And we're going to go after the individuals that used to own the company, because they're the ones that are culpable. So essentially, this is really tough, Saul, because it really kind of puts the owners of a company who want to sell a company, it puts them in a horrible position. They're going to really want to do they're going to want to do a very thorough review of everything before they sell the company. They're going to want to make sure that there is absolutely nothing they need to worry about, because when they sell the company, the buyers are going to be incentivized to turn everything into the government. because they get a free pass. This is really important. This is really, really important. And everyone on this call, especially, the owners of home health and hospice agencies, need to understand this. Because if you're going to be selling your company, you have to understand that whoever buys it, they're going to be incentivized to really look at that company very carefully, and they're going to, it works to their benefit to tell the government of everything you've done wrong. Next slide. All right, so let's talk about, just generally what's going on. Well, it was a big year this last year for the government in terms of the False Claims Act, $2.68 billion. That's up from 2022, which isn't surprising, frankly. I mean, they're picking back up after COVID. More than 1.8 of that was from healthcare. Now, I think it's very interesting to me. More than 712 whistleblower cases were filed. The highest number of settlements and judgments in ever, really, in a single year, 543. So I mean, the activity is increasing, and the government's getting involved, and whistleblowers are filing more and more cases. So, once again, I mean, this really kind of points to the fact that you need to have an effective compliance plan in place. Salt?
Yeah, Robert, just kind of to jump in there, I wonder if the significant increase in whistleblowers is due to, companies responding to the government kind of really focusing on individuals at all levels. So, like we talked about earlier, how the government is really taking, a positive note for companies putting in, language in employee, compensation plans and onboarding documents, talking about, creating fostering an environment of compliance that these employees are like, hey, I see wrongdoing that's going on. I know I might have some liability. It's going to behoove me to, file a whistleblower claim against my company. Employees are no longer just going to be able to blame the higher ups or the company itself, that the government's going to come after anybody. So it really is incentivizing folks at all levels to file whistleblower suits if they see any wrongdoing.
Very possibly. Good point. Next slide. Now, this is a very interesting slide to me. When I was still with the Department of Justice, and it was a long time ago at this point, but when I was with the Department of Justice, that was under Attorney General Reno. And at that point, she really made the headlines when she pointed out that healthcare fraud was the #1 white-collar priority of the Department of Justice. And that was a big deal when she said that. They don't say that anymore. They don't publicize it. But if you look at the numbers, that's what's going on. That's life. If you look at these are the numbers just for DOJ's fraud section. That's the section here in Washington, D.C. Okay, these numbers do not include prosecutions for the 94 U.S. attorneys' offices around the country. So these numbers are limited to the DOJ fraud section here in D.C. But if you add up all the numbers for foreign corrupt practice cases and bank fraud cases, mortgage fraud, federal programs, securities, commodities, corporate fraud, crypto, all this stuff, none of it all together, you add it all up, it doesn't even get near healthcare fraud prosecutions or convictions. Healthcare fraud is the 800-pound gorilla. There's no question about it. And the reason I point this out is the folks on this phone need to understand that they are under the microscope. This is the focus of the federal government prosecutors around the country, including the folks in D.C.
The funny thing is, Robert, is, in the news, all you hear about is, the crypto and the business fraud, Bernie Madoff or Enron. You never hear about the high level, healthcare fraud that's going on. But as you point out, the numbers show how significantly prevalent, the government is targeting healthcare fraud and how prevalent it is, comparatively, to those banking and corrupt fraud. So it's kind of interesting how that comes about. I guess you could say, healthcare fraud isn't the sexy fraud that, makes the news.
Yep. That's true. Yep. Next slide. Okay. Now this is an interesting slide, and I threw it in there just because I think it tells a story. These numbers were issued fairly recently, about a year ago. It came out. It came out last fall by the U.S. Sentencing Commission. And the U.S. Sentencing Commission, these are the folks that they work with the courts, and they issue all the statistics related to the sentencing guidelines, and they analyze all the criminal convictions around the country and determine what has happened with regard to the convictions. And interestingly, they found, under the sentencing guidelines, of course, organizations that have an effective compliance plan are eligible to get a break in terms of sentences, criminal sentences. Interestingly, out of 5,000 organizations that were criminally prosecuted over this period, a 30-year period that they looked at, only 11 of them were eligible to get a break because they had an effective compliance plan in place. That is just remarkable to me. And it points out the fact that even today, there are so few organizations that have really taken the time to sit down and put together effective compliance plans. Now, I will say, Salt, this is across the board. It's not limited to healthcare. And I do believe that if you were to look at healthcare, healthcare really, and it's my belief, and I have, I'm biased because I've always been in healthcare since, as you know, I'm a recovering hospital administrator. I've been in healthcare since 1984. Healthcare really led the way when it comes to effective compliance plans ever since the 90s. But so few organizations have put in compliance plans. And this really points out why it's so important to have an effective compliance plan in place.
Well, why do you think companies aren't putting in more compliance plans? Because to me, and we work in this business, it might seem a pain cost, up front, but as clearly we've seen, in the back end, it can save you hundreds, thousands, millions of dollars.
Well, I think that slowly they're starting to, but it's, banks now have them, financial institutions now have them, but there are other organizations, oil and gas, other organizations that are subject to regulatory inspections and the rest of it that are starting to put them in place. But it's just something that takes time, and they just haven't. Next slide. Okay, so we're going to talk about some of the cases that we've seen, and we're going to try to focus on Texas cases. Lord knows there's been enough of them. You want to lead this, Salt?
Sure. Yeah. So what these cases we're going to talk about kind of really highlight is the common issues we see across home health and hospice companies. So for instance, this case out of Houston, a husband and wife couple, were engaging in healthcare fraud. And what the government found was that the wife was obtaining, patient referrals by providing illegal kickbacks to marketers and patients, and then bribing physicians to authorize medically unnecessary home health services. And that, even the husband then admitted that he was filing fraudulent cost reports to Medicare and attempted to disguise these kickbacks as legitimate business expenses. And then, even down in McAllen, we have a case of this medical director who was involved in a scheme of submitting over $150 million in fraudulent claims to Medicare for hospice and home health services. And so what was he doing? Well, the government said that this company with whom the director was working for were telling patients that they have less than 6 months to live, qualifying them with a terminal prognosis when they weren't even, terminally ill. And then they were going so far as even sending chaplains to these poor patients to kind of create this, environment of, you're terminally ill. And then the company was also making, the medical director fees contingent upon these agreements to certify these patients for hospice care when they weren't qualified. And then, as part of this agreement, the director was getting these illegal kickbacks that included luxury trips, bottle service at nightclubs, and other kind of perks in exchange for his work in certifying patients for hospice care when they weren't eligible. Next slide. So again, we have another home health owner who was filing fraudulent billing claims to Medicare for medically unnecessary services, and then he was also paying medical clinics for these home health certifications and illegal patient referrals. And then once again down in McAllen, we have another owner of a home health agency who was submitted to 45 months in prison, for healthcare fraud. When once again, what we're seeing over and over again is that they're getting reimbursed for home health services that were not provided. Physicians are authorizing, patients for unmedically necessary, services. We have illegal kickbacks that are being paid in exchange for patient information. And then they're using, fraudulently obtained Medicare numbers to submit claims to Medicare in order to see these reimbursements. So again, across these 4 scenarios, you're seeing the same thing over and over again. Certifying patients who are otherwise not eligible for hospice or home health care. There's, illegal referrals for patients, and then, receiving illegal kickbacks. Next slide.
Yeah, these aren't.
Yeah, go ahead.
Yeah, these aren't. These 2 examples are not Texas, but I think that they're indicative of what we're seeing around the country.
Yeah, I mean, we have cases here in Michigan and Arizona, which, they're not in Texas, but again, they're once again indicative of kind of the textbook examples of fraud that's going on in among home health and hospice agencies. So, here in Michigan, we have an individual who was already excluded from Medicare, who purchased a home health company, kind of as a straw ownership, using others to conceal his identity. And then that they were then billing, Medicare for all these services that were never rendered, and then, transferring all the funds they received to these, illegal offshore bank accounts. And then even down in Arizona, you have this this home health agency who was, engaged in illegal kickbacks as part of this patient referral system of a friends and family program. And then they were also getting in-kind payments for food, internet travel, and other expenses. That once again is an example. And what's notable here is the Arizona case came about because of claims from a former employee. So here you have an example of a whistleblower, filing, a claim with the government saying, hey, there's all this illegal, activity going on. You should really look into it. Next slide. So again, those cases really, again, textbook examples of what you working in the home health and hospice, world really needs to be on the lookout for is, certifying for services that are not medically reasonable or necessary, watching out for, illegal referrals or illegal kickbacks, which will kind of start going into the legal side shortly. Using straw purchases of companies when you're either excluded from Medicare or Medicaid, and trying to hide your business activity from the government. It may seem good up front, but it's all going to come back to bite you in the end. Robert, do you have anything?
No, I think this is why we're talking about the kickback statute. And, the kickback statute, if you look at all these cases that we've just discussed, there are a number of similarities. First of all, on the criminal side, there are two things that almost every case involves. One was, it was a violation of the kickback statute, okay? And the kickback was either they were paying somebody something for referrals, or they were engaging in some type of business practice that it didn't meet the safe harbor. And we'll talk about the safe harbor in just a minute. Okay, that was one type of problem. The other type of problem was that they were engaging in some type of certification practice or documentation practice that was either false, or they were certifying for services that weren't medically necessary. So, that was that type of fraud. But the kickback statute is one that is very, very common with respect to home health cases. It also comes up regularly on the hospice side. The statute itself is something that's been around for a long, long time. It has a very interesting background. It started out just as a misdemeanor, and in the very beginning, it was only a misdemeanor, frankly, and it was only $10,000, and it was, it was something that it didn't even require proof of knowledge of knowing and willful conduct. They had to amend it in 1980 to actually add that in. So they amended it in 1980. Geo, next slide. And but that didn't turn out to be even sufficient, so they had to come back and they had to amend it again. And frankly, they had to amend it under the Affordable Care Act. And when they amended it under the Affordable Care Act, I believe they went too far, because what they did was the previous definition was it was a crime to knowingly and willfully solicit, receive, offer, provide any type of remuneration. Remuneration is a crazy word, but it essentially means anything of value in return for referring or arranging or essentially, you can't give anything of value in an effort to induce a referral. Okay, that's the bottom line, right? But what they did under the Affordable Care Act is they said, well, we're going to take knowingly, okay, and we're going to say you no longer have to have actual knowledge. What does that mean? Wow. And we're going to say willfully, you no longer have to have specific intent. So essentially, they watered down the knowledge and the intent requirements under the statute, so that now, essentially, if you knew what you were doing, in other words, when you engaged in the conduct, if it wasn't a mistake, and you knew that you were paying somebody to do something, even if you didn't know it was against the law, that could be a violation, a criminal violation of the anti-kickback statute. Okay, so it's very easy to violate the anti-kickback statute, and it's a criminal statute. Next slide. It's a criminal statute. They've raised the amount, $100,000, 10 years in prison, and it's really easy to violate it. Okay, it only requires one purpose. So, there's something called the one purpose test, which means that even if, you had 3 reasons for what you did that were perfectly appropriate, and in fact were for the benefit of the patient, if one reason you did it was to induce a referral in violation of the statute, it's still a criminal violation. Okay, so that's a real problem. That's a real problem. So it's easy to violate the statute. It's a criminal statute. and it can, result in you going to jail. Next slide. Now, the problem with the statute, of course, is it is shockingly broad. It is so broad, in fact, that they have had to, rather than amend the statute again and again and again, which we've already shown they've had to several times, right? Because they've had to change the definition, that they've had to, they've changed it from being a misdemeanor to a felony. They've changed it from what's required in terms of knowledge and intent and the rest of it. But they've also had to essentially make exceptions, or they call them safe harbors to it, right? In recognition of the fact that it is so incredibly broad, Congress has essentially issued these safe harbors, and safe harbors are these rules that say, if you follow these guidelines, even though technically what you're doing would be a violation of the statute, we believe that it would not constitute a significant risk to the program, and therefore we would not prosecute it. And they've done this now. Congress has done it, 11 times. So there are 11 statutory safe harbors, and OIG has gone in and done it using the rulemaking process through the Federal Register 36 times. So together, there have been 47 safe harbors to this rule, or to the anti-kickback statute. That gives you an idea of how bad, in my opinion, this statute is. When you have to have 47 examples of, this is the rule, this is the statute, and if you violate the statute, we're going to throw you in jail. But if you do one of it, but we're going to have these 47 safe harbors that, if you fit within these safe harbors, we'll make an, we won't throw you in jail. There's something wrong with the statute, in my opinion. What do you think, Salt?
Yeah, and I wholeheartedly agree. And even as you'll go into shortly, even the safe harbors themselves are complex and oftentimes require, some sort of legal analysis to determine whether, one's conduct falls into, one of the 47 safe harbors. So, the statute has just created a legal minefield for healthcare providers that they have to kind of tiptoe through to make sure that, all of their, business arrangements and conduct are okay under this increasingly complex statute.
It really is. It really is. Next slide. We're not going to talk about all 47, or we'd be here all week. But two of them that we are going to discuss. We're going to talk about the personal services and management contract safe harbor, and we're going to talk about the employment safe harbor contract. I don't think we're going to discuss the small entity investment safe harbor, but these are the top three that you're going to run across. If you're a home health or hospice agency, these are the top three you would normally see in your business or run across, in your business. Next slide. So let's talk. Salt was just talking about the fact that these are complicated. Yeah, they're complicated. You got 47 of them, okay? And this is an abbreviated version of one of them. All right? This is the personal services safe harbor. Okay? And essentially, what this is, let's say, for instance, a good example of this would be, let's say you want to hire a medical director. Okay? Well, essentially, this would be the safe harbor that you would want to make sure that your agreement, your contract with your medical director, makes sure it's going to meet these requirements. And the big ones that the folks on this call are going to be very familiar with is, the methodology for determining the compensation. That's something that I know you're very familiar with. It's going to be set in advance. It's going to be consistent with fair market value and an arm's length transaction. okay? It's not determined in a manner that takes into account the value or volume of any referrals, okay? That's the problem. In a perfect world, folks, let's just be real clear. In a perfect world, for all the home health agencies out there, you would not be getting referrals from your medical director. That's in a perfect world. But that's not realistic, okay? So if you're going to be getting referrals from a medical director, you need to make sure that you're not basing his or her compensation on the volume or value of any referrals, okay? So you got to be very careful because these rules, it's got to be in writing. It can't be less than a year. There are all kinds of rules that have to be met. And it's very, very important that you get your attorney to review your medical director agreement, okay? These are not something that you want to pull off the internet. It's not something you want to crib, get from somebody else. These rules have been changed as of December 2021. All right, so if you've got old contracts, they're no good. They changed the rules in 2021, which, it's only a few years ago. So unless you updated all your contracts, make sure that your contracts have been updated, not just for medical directors, for anybody, okay? Now, same thing for those of you, this would also cover if you employ marketing folks, okay? That's really probably your biggest risk. How are you paying your marketing people? Very, very, very important, all right? If they are not a bona fide employee, and that's one of the things we're going to talk about in just a minute, if you're paying them as an independent contractor, are they, do they meet the personal services and management contracts safe harbor? Very important. Make sure you have a health lawyer look at these contracts, make sure that they're being paid properly, because if in fact they're not, you've got a problem. And I will say, for home health especially, that's one of your biggest risk areas is marketing people. Okay, whether you call them a community rep or whatever you call them, be careful. That's a big risk area. Next slide.
Robert, real quick, under that employment safe harbor, what issue do you think you see most often? Would it be determining the fair market value?
Are you talking about the personal services safe harbor or employment?
Yeah, the
personal services. Personal services safe harbor. Fair market value is one thing, but probably fair market value is probably the biggest issue when it comes to medical directors. When it comes to marketing people, it's almost always value or volume. We just can't seem to get these folks to understand you cannot pay them based on success, based on their ability to, based on referrals. I know, and I understand it. This is America. We're used to rewarding people based on their ability to do good work. But you can't do that in healthcare. It just doesn't work. You have to be very, very careful. If they don't qualify as a bona fide employee, you cannot base their compensation in a way that varies by value or volume, period. Now, if in fact they are a bona fide employee, then you can. Okay, but are they really a bona fide employee? And that's the issue. If they're a bona fide employee, then you can set their compensation however you want to set their compensation, but you better make sure that they're going to qualify as a bona fide employee. And there are a number of issues that have to be met. It is not enough to pay these folks using a W-2. That will not cut it. That is one of I don't know what it is, 18 or so different, I know we only have 13 here. I think that there's more than that, though, factors that have to be taken into account, okay? So be very careful, guys. This is a big deal in Texas. I know that in the Southern District of Texas especially, they are very keen on looking at whether or not a home health or hospice is properly categorizing marketing people as employees versus independent contractors. Be careful. Be careful. Have all of your folks looked at by a qualified health lawyer. Please. Next slide. All right, fair market value. This is let's talk about the medical director issues. I mean, this is something that came out. This is not a new issue. I'm glad you kind of asked this question. So, this is something that OIG's been worried about for a long time too. I will tell you, I mean, the government is concerned about this, and it's not easy sometimes to figure out what fair market value is. And I will tell you that fair market value for a doctor in Dallas is different than fair market value for a doctor in McAllen. It's different. And if you're my client, I'm probably going to tell you that it's not that expensive. We'll probably bring in a third party to give us a number, on what to pay these people hourly. It just depends on what it's for. But we don't want to overpay them, that's for sure. And the other thing to keep in mind is, the problem is, of course, if there's an audit, one of the first things they're going to do, you may be tempted to say, well, medical director, we're going to pay him $1,000 a month. Not a lot of money, not a problem. It's not enough to just give a flat fee of $1,000 a month. If there's ever an audit, the first thing the government's going to do is they're going to come in and they're going to say, well, where's the documentation that the doctor kept for what he did for $1,000 a month? And what do you think the doctor's going to have to show for what he did? Salt, what do you think the doctor can show?
I mean, he's probably going to show them his, contract that kind of hopefully outlines what he's supposed to do.
More than likely, he's not going to have much to show at all. Maybe maybe he'll have some phone records, but the fact is, doctors are really bad documentarians. And if he can't show that he came in and did, let's just assume that fair market value is $250 an hour, okay, in this particular geographic location. If he can't show that he did 4 hours worth of work, okay, chances are he probably can't show much of anything at all. The government's going to assume, well, if he doesn't have any documentation at all, what's the government going to assume? The government's going to assume that the $1,000 he got was just payback for any referrals that he made to the agency during the period. That's the problem. And that's why it's so important that all this stuff, you've got to have a good compliance plan in place. You have to have a valid medical director agreement that meets the safe harbor requirements. You've got to have people that go through and periodically audit all that, internal auditing and monitoring. That's the most important element of your compliance plan. And you got to make sure your doc is actually documenting what he's doing to earn the money that you're paying him each month. Okay? Because otherwise, the government can allege that you're paying a kickback. And remember, how many parties are there to each kickback? Not just one. It's not just the doctor. There's always two parties to every kickback. Next slide. Salt, you want to cover these?
Sure. These are just some examples of problematic areas, with respect to kickbacks. So, as Robert mentioned, you really want to take account of the business arrangements that you have, with an individual who might be referring business to your practice. We've also seen issues with lease arrangements. Again, the medical director, contracts, making sure that they're valued based on, fair market value. One thing that, I know Robert has mentioned previously, and we see often is, bringing food and other things of value to, your practice or office, It's a commonplace issue, and technically it could be problematic. People will say, oh, they just brought in some chocolates for the holidays. Technically that's a violation. Now, is the government going to come after you because there was a box of chocolates, or some food left over for the holidays? Likely not. Yeah, but, we do get questions when it's technically, not permitted. Other things we see, issues with is, agencies who give out loan or research or grant or speaking fees to individuals who might have referrals. A particular concern we see often is those physicians or entities who could have a financial interest in your home health or hospice agency, especially if they're sending referrals to you. Giving this remuneration in the form of cash, gift, or other items of values to patients or other folks who are being referred to your office or signing up for your service. All of these things are kind of just the general day-to-day problematic issues that we see. Robert, you have any others you want to add?
Nope, I think that's fine. Next one. Okay, one more point about the kickback statute before we talk about some other statutes very quickly. When they passed the Affordable Care Act, one of the other little kickers that they threw in there is they said that violations of the criminal anti-kickback statute could also be pursued as violations of the Civil False Claims Act. So that's very interesting. That doesn't mean that they have to do one or the other. And in fact, we've seen instances where the government in the Southern District of Texas, they convicted someone of criminal violations of the anti-kickback statute, and then as soon as they got those criminal convictions, they turned around and sued them for the same conduct for violations of the False Claims Act, and they got a judgment. So it's just something to kind of keep in mind. Next slide. Now, just very quickly, because we're getting kind of tight on time. Some of the other statutes that they come up with when pursuing home health and hospice cases, just the general anti-healthcare fraud statute 1347, obstruction of a federal audit. You got to be very careful with the government if you're ever audited. If the government shows up, if they issue a subpoena, that is not the time to do spring cleaning. If the government shows up, if you hear that they're asking questions, don't start destroying things. Don't start, shredding documents. Don't tell your people that they can't talk to the government. Call your attorney, okay? Get your attorney involved as soon as you can and let them kind of walk you through the process. That's the safest way to deal with this. Next slide. Identity theft. This is less of a problem today than it was a year ago, okay? And the reason for this is, but prior to last summer, and this is significant, prior to last summer, the government was throwing an identity theft charge on just about every indictment. And it was because, anything that you did wrong, any kind of wrongful billing, the government was saying, identity theft, because, it shouldn't have been charged, or it was upcharged, or billing for services not rendered, or billing for services that were not medically necessary. Therefore, they were improperly using the patient's identity, to commit fraud. Well, they finally took that up to the Supreme Court. The Supreme Court said, that's overreaching. You can't do that. You can only charge identity theft if the underlying conduct, if that's the crux of the violation. So we're already starting to, and see, the reason why the government was doing this, it was really, really pretty tricky, because if the government charges you with identity theft, that is with aggravated identity theft, that's an automatic 2 years on top of any additional sentence that a defendant would get, okay? So the government was using that as leverage to force defendants to accept a plea, all right? Very tricky, all right? So once the Supreme Court last summer came down and said, no, not so fast, you can't do that, All right. Now we're starting to see the government, they're not throwing identity theft out there anymore, unless it's actually identity theft. Unless the defendants have actually really engaged in identity theft. So we're not really seeing that out there anymore, but it's still something you need to be cognizant about and know that this is something you got to worry about. Okay. Next slide. Some of the, you want to briefly talk about these real quick?
Yeah. So, just some other common criminal statutes we see, as Robert talked about earlier, false claims are going to be an issue, especially with, respect to the anti-kickback statute. It's going to cover, either false claims here or false statements. I think overall the takeaway here is, you can't knowingly, submit any false claim to the government or make any false statements.
Now, just to be clear though, this is the criminal false claim.
Yeah, this criminal, not the civil that you.
Yeah, not the civil. Yep. Yep.
Yeah. Next slide.
Yep.
Yeah. So I think. Yeah. Go ahead.
This one, these are all pretty straightforward stuff, but I really thought that this last one here, this last little part about allowing unlicensed staff to provide care. Earlier this year, there was an individual in Laredo, a nurse, who worked from 2017 to 2019 in multiple hospitals and home health companies impersonating a nurse. And she was finally caught. Now, for the folks on the phone, how are you allowing someone to work all these years for your companies? Just because she says she's a nurse, is nobody checking to make sure they have a license? She wasn't licensed. Wow, this is crazy. So the point though here is, now, they prosecuted her and all that kind of stuff, but the point though here is, what are you doing? You need to be checking these folks, obviously, before they walk in the door. Make sure they have a valid license. Keep a record on when does their license expire, okay? And you need to have a tickler system set up so that you're verifying that, in fact, their license has been renewed, because we recently had a case, I have to tell you, wasn't home health or hospice, but it was another case where a nurse practitioner just allowed their license to expire. Okay, what do you do about that, guys? All these claims then are no good. You got to have systems in place to make sure that all these folks, that their licenses are renewed, and that in fact these claims that you're submitting to these payers, that they're being, that they're being performed by people that are properly licensed. Next slide. Billing for services not rendered. It happens. Still, it's unbelievable, but it happens. Doesn't really happen that much in home health and hospice, but it happens. It happens more. All of these really are more on the personal care side. For those of you who have personal care attendant companies, that's really where this is. So be careful. Texas has not been as aggressive as they have been here in Virginia and Tennessee, but they're out there. Salt?
Yeah, I agree there.
Next slide. Next slide.
Yeah.
There we. Yeah. All right. So what would you say about this, Salt?
To kind of wrap things up, it really behooves you, in the home health and hospice world, to really evaluate, your business relationships with potential referral sources, because, there are multiple civil and criminal statutes that can come into play that could affect, you going forward based on, your contracts, leases, or other payment arrangements. So, as an attorney, it's really important that you obtain legal counsel to help you go through all of these arrangements to make sure that you're not violating any of these civil or criminal statutes, because they could really, arise in not only fines, but potential jail time. Next slide.
Excellent.
Yeah.
So what do? Let's say, for instance, we don't just have owners of agencies here on the phone. What if you're the chief nurse, or you're working for an agency and you identify a problem and you bring it to management's attention and management blows you off? Do you continue working there?
Absolutely not.
No, you can't. You can't. You cannot continue to work there. You only really have two options. You can leave your position, and then, you can leave your position and go somewhere else. You can leave your position, file a complaint with the OIG or whatever. That's up to you. There really isn't a squealer statute. There is no law that says you have to turn them in, unless, of course, you have been involved in the problem, okay? Let me give you an example. You're sitting outside, you're downtown, you're sitting outside the chair, you look across the street, and you see somebody rob a bank. And you say, wait a minute, that's my next door neighbor robbing that bank. There is no legal obligation for you to turn your neighbor in, okay? But if your neighbor runs over to you and asks for a ride home and you give it to him, now you're part of the problem. Now you help conceal the crime, okay? That could be misprision of a felony, all right? You would have an obligation to turn them in. You see what I'm saying? So, if you're working for an organization and fraud's going on, you may have an ethical obligation to report something to the OIG. But we can't tell you that you have necessarily a legal obligation to do that. So what's your take on this, Salt?
I mean, it kind of goes back to what I mentioned earlier, and sticking your head in the sand. I mean, if the government has just put in place, so many incentives to, do the right thing, if you find yourself involved in any, civil or criminal misconduct, that, there's no more just, putting your head in the sand and trying to ignore it. It really behooves you to, notify, someone in authority, whether that's the federal government or, a private payor, if there is any misconduct going on, if you are part of the problem or, involved in this.
Yep. That's right. That's right. Okay. All right. Next slide. Okay. So if you do have a problem, if you find out that there is an issue out there, contact your lawyer. Try to determine the focus of the investigation. Is this just administrative? Is it just a money issue? Is it a civil issue, a criminal issue? Try to get ahead of it. Don't antagonize your employees. Take the initiative and try to work towards a global resolution. Try to work this thing out. Most of the time you can. More often than not, you can fix these things. And that's the beautiful thing about most of these problems, is that if you do have a compliance plan in place and you're actually trying to fix the problem, and it's a real living compliance plan, more often than not, you can fix any mistake that you make. So we encourage you to put that compliance plan in place, have a compliance officer, work through the problems that you identify, make any kind of repayments that need to be made, have your contracts looked at ahead of time, periodically review your contracts, make sure that they're working the way they're supposed to work, and just take good care of your patients. Next slide. And that's it. Gio, do we have any questions?
There is a question. So it says there's a lot of emphasis on provider fraud, but what is our personal liability if we work for a payer?
What? Okay. if you work for a payer, well, that's interesting. You know, that's a very interesting question. There is, you know, if you work for a payer, what is your liability? So let's talk about that for a second, because there is a fair amount of interest these days on the government's part about payer liability. And I will tell you that the government has been going after payers. They have not been going after payers criminally, but they have been going after payers civilly, okay? And mostly it has involved payer misconduct, because the payers have been going in and adjusting the diagnoses on, you know, they've been adjusting the patient diagnoses because they've been trying to ratchet up, you know, the payments on the managed care side and the rest of it. But, you know, theoretically, yeah, you've got some exposure there too. You know, if you're working for a payer and your company is telling you, go through all these records, we want to increase the acuity of all these patients. We want you to go through each one of these records, and we want you to identify any and all diagnoses that the providers did not identify, and we want you to add those to them because we want to be paid more by CMS, you know, and you do it. I think, you know, could you have some exposure? Yes, possibly so.
Other than that, I don't think we have any other questions.
Okay. I think that's all the questions for now. But as always, feel free to give me a call or give Salt a call. Our phone number is on the last slide. It's 202-298-8750. 202-298-8750. And you should feel free to give us a call, and we'd be happy to talk to you. Have a wonderful week.
So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Robert Liles and Robert Saltaformaggio. Everyone from today's webinar will receive a copy of the presentation tomorrow via email. And if you have any other further questions, like Robert said, please give us a call. But other than that, have a good Wednesday and take care.